Good morning. Welcome, welcome. It is a real delight for the law school to be hosting this conference and to have you all here at the University of Minnesota Law School. And it's really my pleasure to kick off today's event. This is really going to be an incredible program. I'm really pleased to see so many of you here today. This is the fifth annual conference of the Rabina Institute of Criminal Law and Criminal Justice, and it's always a terrific day. The fact that nearly 200 of you are here at the law school on a Friday morning is quite a feat and a testament to the Institute and the speakers that are assembled. The law school is very proud of the Rabina Institute. It was established in 2011. It brings legal and sociological research, theory, and policy together with practice to solve common problems in the field of criminal justice. It's led by my colleagues, Professors Richard Fraze and Kevin Reitz, along with Executive Director Kelly Mitchell. It is a dynamic center, and it does so much for us and makes such a huge difference to the world, really. And like the law school that it's a part of, the Rabina Institute embodies relevance and rigor, creativity, and justice, all of which are reflected in today's program. So the hidden ramifications of criminal convictions for inmates and for those who have already served their sentences, they are extensive, they are powerful, and they are understudied invisible punishments, whether we're talking about disenfranchisement, the disqualification from public housing, welfare benefits and job training, if we're talking about the consequences on immigration status, on licensure requirements and eligibility, access to education, and more. Not to mention the treatment of a criminal history and to enhance sentencing, which of course means that the past impacts the future in dealing with the criminal justice system. The impact is great, not just for felonies, but also for misdemeanors as well. With about 6.8 million adults, or 1 in 36, under federal, state, or local correctional control, these legal, regulatory, and private sanctions are numerous and severe, affecting more people and harder to avoid than ever before. This is a kind of scarlet letter for the modern era that yields devastating and long-standing effects. And this is a topic of enormous public importance. Accordingly, we are honored to do one of the great things that academic institutions do, and that is serve as a convener, bring together leaders and practitioners and policymakers and academics and students and thoughtful dialogue and exchange to grapple with these issues in a really sophisticated way. So we're so pleased that you're here. We've got a great day. A few thanks. First, as always, thanks goes to the Rabina Foundation, whose support has funded so much of the center's activities. The foundation has been an important and stalwart friend of the law school in so many ways. They've helped launch this institute and allowed us to really prove that a research-based institute can make a real and powerful difference on law and policy in a critical area. We hope that others, especially grant makers, governments, and individual donors, will join them in supporting the important work here and elsewhere, but really here. Second, thanks to Kelly Mitchell and her colleagues and team for conceptualizing and organizing all of this. Please join me in thanking the whole team here at the Rabina Institute. I'm also grateful to the outstanding roster of panelists and speakers, and of course, a very special appreciation to all of you who came today to participate, to engage, to learn. Welcome to the University of Minnesota. So I recognize that my role here is really just to be filler, get the room calmed down, get ready to start the main event. So I'm going to pass the microphone over to Professor Fraze and let the important work that we have planned for today begin. Thank you.
Thank you, Dean Jenkins. Again, I'm not Dean Jenkins. I'm Richard Fraze. I'm on the faculty here. I'm the co-director of the Rabina Institute and also of the Criminal History Project that we'll be hearing more about this morning. I want to echo the Dean's welcome to you and thanks for coming and helping us discuss and develop these topics and hopefully move things forward. It's my duty initially to cover some general information about the conference, logistics, just so that we all know where to go and what to do. Let me just sort of set the stage and sort of paint a big picture and show how that relates to the pieces of the program. It is excuse me, there we are. The program grows out of one of our major projects here, which examines the topic of this morning's discussion, criminal history enhancements, the way in which a prior conviction record and sometimes related things can increase the severity of the offender's sentence, sometimes very dramatically. But we're trying to, we picked that as one of our major topics because it's a very much neglected topic and yet a very important one. We consulted with sentencing commissions around the country and practitioners to get a sense of whether that was something they would be interested in and open to discussion of, and they were. So that's how it got launched. Now today we're presenting a lot of that to a general audience, but we're also broadening it out to some matters that might at first seem to be unrelated because they're outside of the criminal justice system, or at least outside of sentencing. It turns out criminal history doesn't just increase your sentence, it increases the severity of your processing at every step of the criminal process, beginning with whether the police are even looking at you, stopping you and arresting you. So it has a pervasive influence through the criminal justice process, but it also has all of these consequences afterwards. And we're going to be focusing this afternoon on two of them, felon disenfranchisement and various other collateral consequences. The Dean mentioned employment being number one. And sometimes these are consequences not just of convictions, but of contacts with the criminal justice system that did not result in a conviction or even a prosecution. So the issue is much broader, but there's some common themes. Of these three seemingly separate topics. They all have in common, of course, the impact, consequences of prior conviction. And it's first thing to notice about that, we're calling this, well now, you'll notice we've added again to this slide, whereas back when we wrote the program, we hadn't thought about our presentation carefully enough, I guess. So the idea is, obviously punishment in the criminal justice system is about paying for the past, for your past criminal acts. But what we do with criminal history enhancements and what we do with felon disenfranchisement and with all of these other collateral consequences is we have offenders paying again for something they've already been punished for as in their sentence. But they're being punished, or at least come down on again and again. So they're paying again and again for this past conduct, which has already been punished. The second thing to recognize about these topics is the way in which they interact with each other. So just as the criminal process sets up a criminal record, and sometimes, as I said, not more than just a conviction record, just contact record, and that then feeds into all of these consequences. But the consequences themselves contribute to disadvantage for offenders, makes it harder for them to get back or get into a law-abiding lifestyle and not return to crime. So it isn't too surprising that many unemployed offenders, offenders who are disadvantaged in various ways by all these consequences, end up back at the front door of the criminal justice system again. And so it's a loop. And the consequences are the effect of criminal convictions, and in criminal process, they then contribute to people coming back into the system. So they're related in that way, too. A couple of other common points to keep in mind here. One of the things that's difficult about criminal history enhancements and collateral consequences is that at the core there are valid justifications for these rules, at least for most of them. I think some people would argue that there actually isn't a valid justification for disenfranchisement, but most people would say, well, at least while he's serving his sentence or in prison, he should not have the right to vote. But then, in some places, it lasts your whole lifetime. So there's a problem of overbroad rules in all three of these areas, and also rigid rules that just apply automatically without any ability to tailor it or to consider case-specific facts. So that's a common point. And finally, all of these in all these three areas that we're looking at today, they have a substantial disparate impact on non-white offenders. Many of whom are already very disadvantaged, and so what are we doing? We're increasing, perpetuating, compounding their disadvantage. So we have to keep that in mind throughout the discussion today. So I think that's enough to sort of set the stage. So I think at this point I'm going to turn it over to Dr. Hester, Reese Hester, who's a research fellow here, and Professor Julian Roberts from Oxford, who will tell you about paying again.